Yes.
Lordship, I'd like to mention item number 14. Lordship, I'd say that this matter may be listed after 4 weeks.
Is it also regarding the scale of pay?
Yes.
Okay. Whether the bus is covered under the present notification? Whether the present notification is on covers?
Yes.
Can it be disposed of? If it covers?
Yes.
Present notification of the government
The presentation
covers this one also.
Yes.
Then we can dispose of, I think.
Yes. She needs to take instructions. So let this matter be called up as per the list, then if that is the case, Your Lordship.
Okay. Okay, we'll see. Oh, okay. Yes.
I'd like to mention item number 17 from the hearing.
Item
70.
17. Make appeal.
Matter can come up after 2 weeks. The leading counsel is in this course.
You're for the appellant.
For respondent number 1.
Respondent 1. Who is for the appellant? Have you informed them?
Yes, sir.
Okay. Mr.
No more on behalf of B.N. Sharma.
Appearing on behalf of Mr. B.N. Sharma, with the consent of the land counsel for the petitioner, prays for listing this matter after 3 weeks. The prayer is allowed. List this matter after 3 weeks. Okay.
Please, Your Lordship.
Yes.
Lordship, I'd like to mention hearing item number 19, mentioning on behalf of my senior Sentiang, Lordship. Lordship, my seniors fixed matter in the court one, so let this matter may come after 4 weeks, Lordship.
Okay. Okay. Whether the respondent is also present? There is
Lordship, I have
private
taken
respondent. Okay.
Taken consent from them.
Okay, Mr.
Nuglayam Konyak.
Nuglam Konya, appearing on behalf of Mr. Santiago Lani counsel for the petitioner, with the consent of the Lani counsel for the respondent, prays for adjournment of the matter for the day and to be fixed after
4 weeks, Your Lordship.
4 weeks. The prayer is allowed. Is this matter after 4 weeks?
Deeply obliged.
Please,
Yes.
Lordship, I beg to mention item number 9. Lordship, in this matter, I'm here to seek instruction. Lordship, if 3 weeks time can kindly be granted.
Non-payment of bills.
Yes.
Lordship,
Yes. You have any objection?
Lordship, if on the next occasion, basing on the instructions, if the case may be
Okay.
disposed of, since 11 years have passed, Lordship.
Mr. Angami, Lani counsel appearing on behalf of the state respondent submits that he is yet to receive an instruction in this matter. Therefore, prays for further, how much time?
3 weeks time.
3 weeks time. Okay. Miss
And April.
and Lani counsel for the petitioner is present. Okay, is prayed for. Come at least this matter after 3 weeks. Let us give one chance.
Lordship,
Lordship,
This
I
second time
receive
only.
prayer for item number 10.
Pain,
Yes.
pain also similar.
Pain also similar.
Okay, similar was it?
I'm deeply obliged.
obliged, Lordship.
Mayor, Mr. Lordship.
Yes.
Lordship, item number 5. Behalf of this moment. Lordship, here is preparing this application, so can we grant 3 weeks of time to file it?
Item
5, Lordship.
5. You want to you are to file affidavit.
Lordship, under preparation.
Hmm?
Under preparation, so.
Okay. Okay.
Signature, so kindly grant me 2 weeks of time to find affidavit.
So who is for the petitioner here? Vim. Okay, we'll grant, but then let the matter be called.
Signatures.
No, let their presence will also be in air, be recorded. So let the matter be called for. We'll grant you.
Lordship,
Thanks.
I'm concerned with the.
Okay, okay, Mr. Sanch. Lani government appearing on behalf of the state respondent, prays for further 2 weeks time.
Lordship,
Okay, the submits that the affidavit is under preparation.
I've sent the offline signature.
Okay, affidavit has been prepared. But, and it has sent, affidavit after preparation has been sent for signature and therefore pray, which is still awaited, therefore pray for listing this matter after 2 weeks. He has also obtained consent from the Lani counsel for the petitioner. in view of the, in view of the above, and as prayed for, list this matter after 2 weeks. Okay.
May it please, Lordship. Lordship, I'd like to mention item number 1, Lordship. May I pray that this matter may be listed on Tuesday, Lordship.
One will call only, the first matter only.
Lordship.
Will pass order.
Lordship.
Okay, wait. Item 1 is the
Lordship.
first matter.
Lordship.
Is okay.
Mr. Lordship, I'd like to mention item 7. Lordship, I'm hearing on behalf of respondent 4.
Praying on behalf of
Respondent 4.
4,
It's 3 weeks time to file their affidavit in opposition.
3 weeks time. And what about the petitioner are present? Hmm?
I've taken the consent of the petitioner
Okay. Miss
and solo.
and Solo, Lani Council, appearing on behalf of the respondent for praise for further 3 weeks time to file affidavit in opposition. She has also obtained obtained consent from the Lani Council for the petitioner. Okay. As in view of the above, and as prayed for, list this matter after 3 weeks. Okay. Yes. Okay. Item 1.
From the supplementary cost list for
For
motion,
supplementary.
item number
Who
20.
mentioned item 1 admission? Who mentioned? Who made a mention? Okay. What is your submission here?
Lordship, I pray that this matter may be listed on Tuesday, Lordship.
Next Tuesday.
Lordship.
You are on behalf of?
Asia, Lordship.
Okay, for the petitioner.
Lordship.
Okay, as prayed for by Mr.
The Blue Mark, Lordship.
Lani Council for the petitioner. List this matter on
Tuesday, Lordship. That is 8 of April.
civil division. Have you taken consent from the other side?
Lordship, here the respondent is yet to appear, Lordship. The sole respondent.
Okay, then next Wednesday, next Tuesday.
Tuesday, Lordship.
Next
8 of
Tuesday,
April.
okay. As prayed for by Mr. Swenson. List this matter on next Tuesday, huh?
Much obliged.
Write the date also. Okay, yes.
Item number 20.
Lordship, there is an interim.
Better. The interim order pass earlier shall continue till the next listing of the matter. Okay.
Much obliged.
Yes. Yes, what is this?
May I please, Lordship, the matter pertains to this honorable court order dated 30/4/2024. I have annexed 1 page 12. This honorable court have directed
Page
the
12,
respondent,
page?
page 12, annexure 1. I will be allowed to read out the relevant para.
Okay,
Para 7 on page 14. Be that as it may, since the parties are in the agreement on the limited prayer made by the learned counsel for the petitioner in view of the said agreement of the parties, this writ petition is disposed of at this stage with the direction the respondent authorities, more particularly the respondent number 4 and 7, to dispose of the representation dated 27/7/2023 submitted by the petitioner for assessment of the compensation by passing a speaking order within a period of 30 days from the date of receipt of certified copy of this order. However, my lord, even after a span of 11 months, the respondents have not come up with any assessment report as part of this honorable court direction.
so your representation has not yet been disposed of.
Yes, my lord. I have even filed RTI, my lord. The RTI reply.
Who is the respondent here?
uh,
Who, otherwise, who is the
For-
respondent in the writ petition?
Respondent for in the writ petition is the executive director, NHITCL. And 7 is a deputy commissioner. General
You
Police.
have submitted this order, copy of the order.
Yes, my lord. As annex, the cover letter, annexure 3, page 17.
Okay. Had Mr. Parking the Chabro, Lani Council, will issue notice,
Yes, my lord.
Lani Council for the petitioner, staff. This is an application filed under section 11 and 12 of the Contempt of Courts Act 1971, read with the Contempt of Court within bracket Gauhati High Court Rules 1977 and Article 215 of the Constitution of India. 4. Non-compliance of the order and direction of this court dated 30/04/2024, passed in WPC 310/2023, directing the respondent authority to dispose of the representation submitted by the petitioner by passing a speaking order within a speaking order staff. Issue notice returnable by 4 weeks. The petitioner shall take steps upon the respondent by a registered post with AD as well as by user process within a week from today. List this matter after 4 weeks.
Item number 21.
May I please, Lordship? Lordship, the instant IA is in application praying for continuance of delay of 552 days in filing the resolution petition, Lordship.
Will issue notice?
Lordship.
Okay, hard Mr.
James Nima.
Land Council for the James Newai and Newmai, Land Council for the petitioner staff. This is an application filed under section 5 of the Limitation Act, read with section 173 of Motor Vehicle Act 1988 for condonation of delay of 552 days in filing the restoration petition staff. Issue notice returnable by issue notice returnable by 4 weeks staff. The petitioner, so the applicant shall take steps upon the respondent by a registered post with AD within AD as well as by a usual process within a week from today staff. List this matter after 4 weeks.
Item number 22.
May it please the Lord. My lord, this I was filed for incorporating the administrative approval on the prayer as well as per the direction of this honorable court, Lordship.
Okay.
Lordship, may kindly come to
This court granted leave. Whether this court granted leave to file.
Yes, Lordship.
Okay, where is that?
May kindly come to page 8 at annexure 1. Page 8, annexure 1.
Okay.
Yes, I may be allowed to read. Learned censor for the petitioners take 2 weeks time to file an amendment application incorporating the impugn approval order, Lordship.
You were asked to file amendment.
Yes, by incorporating the impugn administrative approval order.
Since the court is allowed, we can allow. Okay,
My lord, in
Yeah,
the,
Mr. Lordship.
yes, any,
Lordship, I filed the IA 133, that is a IA 123, questioning the maintainability of this petition.
Okay.
Petition, Lordship. In my IA, Lordship, I've questioned the maintainability on the ground that the petition has not challenged the approval.
the approval which
Lordship.
by this IA, they have annexed, it appears.
prior to the petitioner.
Okay, now probably the court has granted leave.
No, lordship, to amend, lordship, but the petitioner has to file an amendment petition to amend the whole petition, lordship.
Now you say
But-
after this, you have to, you are yet to file amendment petition.
My
You have to amend your writ petition,
Lordship,
lordship, I
file a
filed,
recasted one.
lordship, I filed by way of lordship, for incorporating the.
No, why? You
stem.
were allowed to amend your writ petition by incorporating the present document. Allowed 2 weeks time to file necessary amendment application. Your amendment application incorporating the approval order. You are allowed to incorporate the approval order and to amend the petition. Why this IA?
Lordship, if that is the case, can it allow 2 weeks time so that I will file the necessary amendment petition, lordship?
It was he was allowed to file amendment petition only,
Yes, yes, lordship.
isn't it?
lordship, for filing an amendment petition, lordship, to an IA, lordship, the petition should seek the permission of this honorable court to an IA to file the amended petition, lordship. And
So that is why I was
IA
asking whether he was granted leave. So it appears that by this order itself, he was allowed to file amendment petition. Already allowed.
Amendment
Yes,
application, amendment application, lordship. Incorporating the impeachment order.
Time to file an amendment application.
But prior to that, lordship, my peace, lordship,
Hmm.
lordship, IA wanted clarity prior to the filing of this, prior to this order date 25 to 25.
Hmm.
Lordship, I filed my IA 133 on 9/9/2024 on maintainability, asking the question of the read,
Hmm.
stating that
You have not yet
the
filed
appli-
affidavit.
Yeah.
Affidavit in opposition, not yet filed affidavit in
I
opposition.
filed the.
Now, since they have been allowed to file this application,
Lordship,
Lordship,
since
if-
the honorable court has allowed for the amendment, so lordship, in that case, can you allow 2 weeks time so that I will make the necessary rectification and then I'll
and
file it,
the-
lordship?
If lordship may observe that all the IAs and along with the writ petitions will be taken up together, lordship.
okay, then without amending the writ petition.
No, that's for the petitioner, lordship,
Okay.
since the court has already filed the order. Because lordship, this IA for amendment is an afterthought, lordship. The writ petition, they have not challenged the administrative approval of
Okay.
the government, lordship.
Heard, Mr.
Tushit,
Line counsel for the petitioner. I have also heard Mr. Faseko Pate, Line counsel appearing on behalf of the. No, state is also, okay, Mr. Yes. Line counsel appearing on behalf of the state respondent number 1, 2, 3, and 4. And Mr. Faseko Pate for respondent number 5. Stop. This is for incorporation. Okay. The Atlantic Council, by filing this application, the petitioner, the applicant prays for incorporation of the impugned administrative approval order number APPT stroke grade GR dash 3 stroke 4 Roman 3 and Roman 4 stroke 38 stroke 2018 dated Kohima 13th November 2023 issued by the Deputy Secretary to the government of Nagaland, to the direct Nagaland, to the Director, Rural Development Blocks, Nagaland, Kohima, as it was not readily available at the time of filing the writ petition. Since this court, by an order dated 25/3/2025, has allowed the applicant to file amendment petition application for incorporating the impugned approval order, comma, the respondent has no objection. In view of the above,
I have objection on that, Lordship, that's why.
you have objection, but then it was allowed already by this order.
Lordship.
File an amendment application incorporating the impugned approval order. Page 8.
6, Lordship,
Yes,
Mr. So-and-so learned for the petitioners take 2 weeks' time to file an amendment application incorporating the impugned approval order. It's not allowed, Lordship.
There is allowed, Lordship.
the petitioner seeks 2 weeks' time
So
to
the
file
learned
an
counsel for the
amendment.
petitioner is allowed 2 weeks time to
application.
file necessary amendment application, Lordship. So you have to first file an amendment application, Lordship.
Incorporating the
No,
impugned.
no amendment petition has been filed, Lordship, till late.
But why objection? Why objection?
Lordship, that's why I was bringing the notice of the Solomon Court in IA 133, filed on 9/9/2024.
Hmm.
I will have filed an IA for maintainability of this petition. And in my IA at page 10, Lordship,
Yes. Yes,
page 10 of my IA 133, Lordship.
so you want to file objection to this?
Lordship, but Lordship, at this junction, I may be allowed to file an objection.
Okay.
Lordship, moreover, the petitioner has to file the amendment petition, recast petition, Lordship.
Now, after allowing this, then he will be allowed to file recast petition.
Lord,
But then if you are to file objection,
Lordship, I may be given some time to file my objection,
but
Lordship.
this, I think, is a necessary order. It was probably,
Lordship, the petitioner, while approaching this Honorable Court,
this was not annexed.
this was not annexed, Lordship.
Hmm.
And Lordship, the petitioner has not make any amendments, make any amendment, Lordship,
Okay. You want to file objection?
Lordship.
Okay. The Mr. Person, okay. You also have objection. Okay, okay, then second para would be, then. Mr. So-and-so, learning council appears on behalf of the state respondent who appeared and accepted notice. Then issue notice, okay. No, accepted notice, however, prays for some time to obtain instruction. Mr. Procedural also prays for 2 weeks time to file objection. Prayer allowed. List this matter after 2.
My lord, in the meantime, as per the order, I may be allowed to file the amended application by
No.
incorporating the,
Amended.
as per the order, I may be allowed to file the necessary amendment application by incorporating the impugned note, Lordship.
Now you see, if that amendment petition is allowed and allowed to incorporate these documents,
yes.
then what would be the necessity for filing objection? It will not be required.
That is why, Lordship, even this honorable court has allowed for the
Amendment.
Yes. This honorable court has allowed for to file an amendment application.
I think this order, which has been directed to incorporate, I think this is the order which is necessary for the purpose of disposal of this writ petition, isn't it?
Lordship.
So whether the objection will objection will help you. Will the
Filing
objection?
objection in present IA,
IA is for incorporation only.
Lordship. So I'll be filing objection to this, Lordship.
My lord, since this
Lordship-
honorable court has already allowed for filing this amendment
No,
application, my lord.
you were asked to file
Necessary
Yes.
amendment application.
application.
That is why, my lord,
Lordship, this
Eh,
home
I-
court is not incorporated.
2 weeks
the-
time may be allowed to
Time to
file
file
for
an amendment.
this amendment
Only
application
allowed to file
for
amendment application.
after making necessary rectification, lordship.
Kindly come to page 8. This
Yes, Lordship.
is,
The learned council,
hmm,
the third paragraph, the learned council for petitions allowed 2 weeks time to file necessary amendment application.
see, in the beginning. 2 weeks time to file amendment application,
The first-
incorporating, incorporating the
Yes.
impugn approval order.
Lordship,
Amendment application,
The first-
amendment petition, incorporating the impugn approval order.
Lordship, that's the.
Anyway, you file
that is the
objection there.
Submission of the
Anyway.
petitioner.
Hmm.
My lord, in the meantime,
And
yes,
so let them
order-
file objection. Let them file objection first.
yes, lord, in the meantime.
You were asked to
allowed
file application.
Yes, to rectify and file the
No.
amendment application, lordship.
No, this is application for amendment. Let them file objection first. Okay.
Lordship, in the meantime, interim may be continued. There's an interim, lordship.
Which interim for what?
Interim for staying the impugn appointment order.
The main.
Yes, lordship. Interim order dated 21/11/2023, lordship.
What was the order passed in the main?
21/11/2023, lordship.
21?
11/2023, lordship. Wait, let me just-
No, that is not listed today. That is not on the list today. Oh, that.
Twenty-one, 2023.
Hmm?
Even in the last,
Just
even in the last order, it was extended. lordship.
21?
21/11/2023.
Interim order.
Yes.
Okay. There is an interim.
Yes, lordship.
Okay. In the main then. Mr. Sun, all of them, huh? List is matter after 2 weeks. In the meantime, sorry. The interim order passed earlier shall continue till the next date. Okay.
Lordship.
Item number 23.
Your Lordship, I'm challenging the judgment dated 27/11/2024 and decree dated 28/11/2024, and the IA is for condonation of delay of 33 days.
Will you soon notice?
My lord.
Okay. Mr. Joshua Seki, learned counsel for the applicant. Para. This is an application filed under Section 5 of the Limitation Act 1963, read with Rule 2 within bracket 2 of Chapter 5A of the Gauhati High Court rules for condonation of delay of 33 days in filing the connected appeal against the judgment and order dated 27/11/2024 and decree dated 28/11/2024 passed by the Court of the Civil Judge Senior Division Kohima, Nagaland in civil suit number 01/2016.
2016, my lord.
16.
Yes, my lord, my apologies, Your Lordship. It's a typo error.
Okay. Issue notice. returnable by 4 weeks. Stop. The applicant shall take steps upon the respondent by a registered post which AD as well as by an usual process within a week from today. List
Well-
this matter after 4 weeks. Okay.
Oblige, your lordship.
For admission, item number 2.
Yes. No one appears on behalf of the petitioner on call. Our Miss Mary Lana Council and Lana PP for the state of Nagaland is present. Anything to be done today in absence of the petitioner cannot. Or in absence of the petitioner, this case stands adjourned.
A week's time may be granted, Lordship. If
Okay,
that's-
list this matter after a week. Okay,
Item 3 and 4, same order.
similar order?
Yes,
Okay,
different complainant, but against the same accused.
okay, similar order, huh? In both.
Item number 6.
They may be granted 3 weeks time, Lordship, to file a affidavit.
Is this also regarding the scale of pay?
Yes, Your Lordship.
Whether the notification covers?
Your Lordship, I'm not in this case. I'm mentioning on behalf of my colleague.
Just a minute, huh? Who otherwise, who is appearing for the state here?
I hope that Pichano is appearing in this.
Just let us see the prayer, huh? Let us just see the prayer once.
Yes, Your Lordship.
If it is a scale of pay, if it
Yes.
covers, we can dispose of also.
Yes, it's regarding scale of.
Yes, it appears.
Then, Your Lordship, as per the new office memorandum.
The new office memorandum will pass similar order.
Let her please be considered as per the OM.
Yes, yes. Okay. We'll dispose of. Okay, we have
We
today,
can-
I think only after one, so it will be dictated in the chamber. Okay, so dispose of as per the
Memorandum.
office memorandum dated, it was 5/4, I think. Okay.
2025.
Okay, 2025. Okay. Hard miss, your miss?
And solo.
Okay, and so no. Land
Yeah,
council for the petition.
My
huh?
name will be reflected as a government council.
Okay, okay, it's merit for that. Okay, land senior government advocate, huh? Okay,
Your Lordship, a time frame of 4 months may be given.
4 months.
Yes,
Like
Lordship.
yesterday's.
Yes,
Okay,
yes.
okay, 4
With the
months.
order, yes, yes.
Okay,
Obliged.
For admission, item number 11.
Please, my lord.
yes.
My lord, I was informed that the petitioner, the case of the petitioner has been considered and then he has been regularized, my lord. I was served a copy of the regularization order by my learned counsel.
Okay, you have received.
Yes.
So it has become infraction.
Yes, my lord, she was
Okay.
supposed to place the order on record. So,
Order, a copy of order is also with you.
yes, I was served one copy, my lord.
Okay, can we just see once? No.
No. Yes, been regularized. It was just, in the body. Yeah. We were supposed to place it before the vote.
Yes, this matter has become infractious.
Yes, my lord.
Okay,
My lord, but if the presence, we can pass it over for tomorrow and then we can close it tomorrow.
Yes.
Tomorrow.
Yes,
Not
madam.
in this case, Your
Since the
okay,
council is not there.
okay. As prayed for by the learned counsel for the petitioner, at least this matter tomorrow again. Okay,
Yes. If I may have the.
yes, please.
From the supplementary cost list for admission, item number 24.
Okay, okay. This is also regarding scale of pay.
Yes, Your Lordship.
Yes, similar order.
One of my colleagues, let
Okay.
me listen next week, Your Lordship.
The prayer is same,
Yes, Your
scale of
Lordship.
pay only.
Yes, Your Lordship. The council is in next courtroom, sir.
Next courtroom,
Lordship, let me listen next week.
next week. Just a minute.
Or pass over, Your Lordship.
Pass over for time being.
Yes.
Okay. For the time being, huh? Okay,
Much obliged.
time being, huh? Oh,
For orders, item number 12.
yes,
I filed a complaints with on behalf of respondent number 10, that is actually in Senate Power.
Hmm.
And on the first of this month, I filed a complaints against warrant on behalf of the respondent number 9, that is Secretary Power Department.
Hmm.
But today the commissioner, he already done. On obsession.
you have already filed affidavit on behalf of all the respondent.
They put the complaints
Okay. No one appears on behalf of the petitioner on call. Hmm?
Next week.
Call, huh? Stop.
None of the petitioner.
Okay. However, okay, Mr. Lanet, additional AG. No, you for respondent number
9 and 10.
9 and 10, submit, is present and submits that affidavit on behalf of the respondent number 9 and 10 has already been filed. So in absence of, however, in absence of the petitioner, the matter stand adjourned. List this matter after a week. Okay.
Item number 13.
Here, the last affidavit filed on behalf of the respondent number 3, that's the Home Commissioner. We have filed a comprehensive affidavit, but all the queries as per the requirement of the government, we have obtained from the BHQ, from the respondent number 2. But on the result of the recall, again, we find some very vital documents were found missing. So we have intimated to the BHQ, that is a respondent number 2. On 3rd March, that is regarding the detailed wet leaves for appointment on compulsory ground under this department. It was also not included in our affidavit. And number 2 is appointment order, service regularization, service confirmation order, and the service sheet in respect of the deceased official. So we are awaiting from the PSU.
Lordship, I
Yes.
have prayed before this honorable court for appearance, personal appearance of the respondent. This honorable court is not willing. Now, it's now 5 years, a contempt pending for 5 years. If this honorable court cannot enforce the contempt of its own direction, where will the petitioner go? Can a contempt be pending for 5 years? His father died 9 years now. And if Lordship can kindly see the previous orders. How many last
Appointment
time?
order not yet issued.
Lordship,
Not yet issued.
No, no, no. They will not. That's why I have been praying before this honorable court for.
No, in the last occasion also, it appears that this court also observed that in view of the matter,
yes,
this court is of the view
Lordship,
that
kindly
the respondent
read
continued
22,
are on the
2025.
last leg of issuing the
Yes.
appointment order in respect of the petitioner. See, but
Last time to place the appointment order before this honorable court, I think it has been 5 or 6 times.
Lordship, that order was passed on the basis of the affidavit filed by the respondent number 3. So we had a good faith that we can dispose of the matter at the earliest. But while examining all those documents, which
Mhm.
were included in the affidavit dated 26 February 2025.
Mhm.
So those documents we were seeking from the PHQ. So of course, it was late, we obtained from the PHQ and thinking that that is a complete documents. And on perusal of those documents, which including in our affidavit, again, we found some vital documents which was missed out by the PHQ.
which
So,
was?
Miss.
Okay.
It was not included by the PHQ. So now we are in the difficulty. Without those documents, we cannot proceed forward.
See, there is already direction by this court.
Yes, yes. Direction is
2
there.
months is 5
Just a minute.
5 years.
Yes, I'm very much aware of the order,
Hmm.
last order. And on perusal of those documents, we found that 2 vital documents were missing.
Say,
which was-
what are those documents?
I have already included in the letter dated March 3rd.
Edit
Second
my
page.
advocate general.
1 and 2, it is
Seeking
still
government
missing.
direction.
This has to be supposed to be furnished by the BHQ.
Just
So
a minute.
without that, we cannot proceed for completion of the process. That's the problem we are finding. So if the honorable court, even though we give and pray for time, but since it is a concluding part. So if the honorable court considers.
Just a minute,
our-
what, just a minute. Regarding proposal for appointment, 3rd March.
Yes,
Director.
and the same.
Why all these documents are necessary at this stage for appointment?
Exactly.
There is a compassionate appointment. So I think.
In other cases, they don't submit this kind of
So,
documents.
see, wait list. Is it necessary for compliance of the order
No.
or appointment order of
Yes,
service
no, sir.
regular?
Even the commissioner, he maintained the list.
Now, can you examine all those? Whether he is entitled or not? Can you re-examine now at this stage?
According to the serial number.
Unless-
I think the petition may not be in the trouble. But the thing is, we have to comply all the administrative.
They are saying the same thing for 5
We have
years.
to comply, it is our duty to comply the administrative procedure.
Both the councils are here. They are saying that they are not sending. Now the learned council is submitting the other thing. When both the councils are here representing
I think
the
officer
respondents.
need to come and I think the clarify.
That
Why-
is
Why 5 years is necessary at least? to
exactly.
issue? I think in this case, officer is necessary. There is miscommunication or the advocate has not properly communicated. We have no idea, but then I think the order was passed on which date? Direction?
Direction was passed on 14 to 2020. 14 to 2020, within 2 months. 2 months has
2020.
become, yes,
Hmm.
2 months has become 5 years. I have prayed from before, if they cannot produce the appointment order, let the respondent appear before the Honorable Court Lordship. I have been praying for a year. But same order are passed by this Honorable Court. What is the use of appearing before the courts
See,
if
this
the court
was in
cannot implement? before the
February
court?
also. Some clarification.
They better come and clarify before this Honorable Court.
That will be forwarded in written to the Director General of Police,
It will take,
Nagaland, and the remainder. Whether you have filed compliance affidavit?
No, I filed respondent number 3, I filed affidavit on 26 February 2025. So basing on that order.
No.
order
You
is-
directed to file compliance affidavit.
Yes, yes.
Have you filed?
Actually, had the DG, had the BSU submitted all those out there filed. But the thing is here, after filing all those, documents, again, perusal of the documents, we found that those documents were missing off. So without that, we did not complete. And the thing is, we want to here, even though by counting the so many years has gone. But the problem, we are not denying, but it is we to complete all the administrative procedure. So
See,
one has to prove that they also. HEOs, we have to update all.
You will not deny
Yes,
even after 10 years also, but then by then the petitioner will not remain
yes.
alive.
We are
Then
aware of that. We are
5
aware.
years, see, 5 years.
Yes, Your Worship, we are very much aware. The plight of the video, we are very much aware.
This is kind of, you see, the torture.
But the problem is, if we.
Problem for filing writ petition,
Yes.
the petitioner. Is noted above. This code expresses justice. Okay, compliance affidavit you have not yet filed.
Yes, no. Yes, I filed an affidavit
Which one?
on
Where do we find?
26 February 2025. And it's number 3, like the Home Commissioner.
Okay, so this is compliance affidavit.
Yes, on my part, we have filed. And I submitted before the annual board, we are the final late to comply the action of the annual board. But the problem, other way, we produce the final documents. I think we found some missing documents.
so who will produce that missing document?
We don't do that. It is within us only. But the thing is, it is our duty to comply all the administrative procedure. If we commit or omit something, then there'll be another.
So it takes 5 years
Yes.
to complete the procedure.
Yes.
I mean, later on that. This honorable court in WBC number 21, 2020 has disposed of with on 14 in 2020, directing to consider the case of the petitioner for appointment on compassionate ground. After that, a seniority list of compassionate applicants was published, wherein the name of the petitioner was serial number 50 and 50. Subsequently, the petitioner had again challenged that seniority list and by filing WBC 115 of 2022, because if it has to be considered as per the list published, the petitioner's name is figured at serial number 66, which was issued in terms of an addendum of 2019. And then the petitioner by filing WBC 115 2022 have challenged that list as well as the addendum of 2019. The addendum says like the appointment on compassionate ground has to be from the death of that deceased employee. However, this honorable court by order dated 5/7/2023 has set aside this unity list, which was put into challenge. And then the attendant was not interfered, saying that it has to be prospective, not retrospective. So now the department has come up with a new list, and then as per the list, since now the name of the petitioner has to be considered as it was prior to the attendant. Her name, his name was figured as serial number 1, ET 123 area. So we have sent a proposal for consideration of his case for appointment to the Home Department on 4th June 2024. So now we are, the process is going on for consideration. It was not like we were being sleeping over since 2020, but there was some developments were there. So in the, how it has been delayed.
Lordship, what happened? My name was placed at serial number 61 because they include all those who died in 1980s and 90s and 30, 40 years who died before in the police department. They included and placed me at serial number 61. These are the tactics. That's why I challenge that seniority list. Then the Honorable High Court questioned my serial number, they say, is at serial number 2. These are the things that is playing. They can appoint backdoor appointment 2,000-3,000 since 2020. Now, why one appointment for compassionate appointment they cannot grant? The injustice that is meted out to the petitioner, it's absurd.
Case of the petition is already in the move of consideration. It's at the final stage. We were not saying that we're not considering it.
Okay.
And then
Miss.
you are-
Judge Jim Ovilani counsel for the petitioner. So I also heard Mr. Interim Song, Lanet additional AG. For the respondent appearing on behalf of the respondent number 3, as well Mr. N. Longkumar for respondent number 2. Okay. And you're for? 1. Okay, then okay. Mr. Mohammed for respondent number 1. Start.
One is already retired, Lordship. Is the respondent number 2 and 3.
The Honorable Counsel for the respondent submitted the case of the petitioner is at the last leg of issuing the appointment order on the appointment order on compassionate ground. However, as the service book of late Kriamba, husband of the petitioner, late Kemba, who is the husband, is the
Petitioner's father.
father. Sorry,
I am the son.
okay. So this was also not sent yet. No, it was. This also has not yet sent.
Substantial document we have received so far, but those documents were changed. Submitted before worship and the issue they have already sent those documents to the
Service book is with whom? With the accountant general. And then why this deputy inspector general required the service book of the
March.
why it is necessary?
These are all
We are awaiting the reply only.
unnecessary things, Lordship.
No idea, but
When it comes to the installation of Harvard, Even for slight mistake of the procedure, some of the.
Yes.
They want to do.
They can appoint 3,000-4,000.
It will obstruct the proceeding.
They can appoint 3,000-4,000 without recruitment. Yet, for one person, such proceeding is needed. Yes, before this honorable court. Lordship, I pray that if they cannot place the appointment order next time, either place the appointment order next time or
For which further 2 weeks,
the respondent.
2 weeks time. For final issuance of appointment order.
As a meeting, of course, we are given a very for time, but to meet all those administrative procedure, I guess if.
Oh my God.
Around 4 weeks. Because
Lordship,
it is not a work of one individual person. Because
Further
we
4
have
weeks
to
time,
file
4 weeks,
for
further
the
4 weeks time
department head.
would be necessary. Stop. Huh?
Yes. And.
Okay, at least it's matter after 4 weeks. So it is made clear that
Lordship.
it is made clear that if the respondent failed to comply with the order and direction of this court by issuance of appointment order to the petitioner within the 4 week, the respondent shall appear before this court in persons on that.
There are two respondents, Lordship.
Okay. Both the respondent we'll fix on. We'll give 4 weeks, but then on the next date, if you till then, if you fail to issue appointment order, the respondent will have to appear. We'll fix out on May. Let us say May 19.
Maybe not lordship, if some direction is given to the agent, according to her.
No,
They
whatever may be.
They are not
may-
party.
The
are not party.
They are not party. It is the respondents. When they are not a party, how can a direction be issued to a person who is not a party to the? No. It cannot be mentioned.
Yes, but it goes to the department. Of course.
Okay, we're giving till May 19, huh? Okay, May 19. And in case the appointment order is issued prior to May 19, the appearance of the respondent shall be dispensed with. Okay.
Obliged.
For orders, item number 14.
Okay.
So if you're the petitioner, this one is directed us to the petitioner, and they are covered by the Indian.
Okay, so we'll pass order according.
There are two directions. One is for scale pay and the other is for arrears from the time of filing the petition.
Arrears, whether arrears cover, I think this notification
Yes,
doesn't cover
does not
arrears.
the areas.
Cover-
But again, still that has not been complied with. So my prayer is that the petition, yes, if the state wants some time, I have no objection to that. If the matter can be listed up again after
Okay.
4 weeks.
It will not cover because it doesn't cover areas. Okay.
Yes.
Okay, Miss S. Maryland, where it is mentioned? Not Mary. Oh, okay, Mr. Iralo, Learning Council for the petitioner is present. You have not yet filed affidavit, no? Okay. Okay, Ms. Sukri, Learning AG, appearing on behalf of the respondent, prays for further 4 weeks. Time to file affidavit in opposition. The prayer is allowed to obtain instruction and to file affidavit. Okay.
On the areas,
necessary.
on the areas aspect, because as far as the scale. is
So
concerned-
scale, they are clear, I think, because the scale
Yes,
is to
now
be
the
given.
areas aspect is
Now the
if
scale will be given, but it's special, okay.
If your lordship. can
Obtain
mention that,
instruction
yes.
obtain instruction with regards to the arrears of salary to be paid to the petitioner.
Yes.
Okay. and to file affidavit if required. Okay, list this matter after 4 weeks. Okay.
Item number 15.
Please, your lordship.
Yes,
My lord, the IA, which is to be considered is the IA for condonation of delay of 1,147 days, your lordship.
yes.
My lord, it appears the notice is still not complete.
Okay,
However, your lordship, here, in similarly situated cases where the GPF were withdrawn by some unscrupulous characters, your lordship, where the state as well as the AG, in a similarly situated cases also we were caught unaware only after the crime was committed by some unscrupulous persons. My lord, here similarly situated cases were also filed before the Honorable Court where the respective departments have borne the expenses. In this case, I'm challenging the judgment and decree of the learned court below that has directed the Office of the Accountant General to pay when we are only an approving authority. We are not a finance sanctioning authority, my lord. So we are challenging that, but why there was a delay of 1,447 days is for years together, we were trying to take up with the state.
anyway, since service is report is still awaited.
My lord.
Okay, Mr. Joshua Sekilani, counsel for the applicant is present. The office, no one appears on behalf of the respondent. The office note dated 11/3/2025 reflects that the notice issued upon the respondent number 1 to 4 is still awaited. In view of the above, list this matter after, or if you want to take fresh steps.
As far as the respondent number 2, 3, and 4 are concerned, they have copies, I believe, is already served.
Okay, after 3 weeks. If after 3 weeks, if nothing comes, then you take fresh steps or by dusty or whatever.
My lord, then 2 weeks, so that.
Okay, 2 weeks, 2 weeks.
My
Okay.
lord, your lordship, oblige your lordship.
For hearing, item number 16.
Yes, your lordship. Lordship, I am on behalf of the appellant. Lordship, my senior counsel is on her legs before courtroom 1. So if your lordship allows, I pray this matter be taken up next week.
Okay, as prayed for by. Okay. Yes. Mr.
No more.
Santila, land counsel for the appellant, which is not objected to by Ms. Cheng, land counsel appearing on behalf of the state respondent. The matter stand adjourned to be listed after a week.
Lordship.
Next week or after a week?
Next week.
Okay, next week. Okay.
Much obliged.
For hearing, item number 18.
Oh. Yes, sir.
Your lordship, is a very short matter.
Okay,
Can we try, your lordship? It's a short matter.
okay.
This is about my land, which was given to the BSNL. This is in Zinabuto, my lord, Zinabuto town. So my land was given to the BSNL without following due process of law. And BSNL is now in occupation of my land. That's the short point. So if the BSNL wants my land, it has to take it only in accordance with the provisions prescribed by law. That is a short case. If you can go to the facts of the case, now very short facts.
Mhm.
When the writ petition. The writ petition. At page 4, beginning from page 4.
It is on page 4.
Yes, madam.
Okay,
Paragraph 3. Paragraph 3.
yes.
Sometime in 1979-80, due to emergent circumstances, on the request of the district administration, the petitioner constructed 28 barracks for police personnel on his plot at Old Town, Zinabuto. Subsequently, some portion of the land was turned into a park. Then 4. That not long thereafter, the park was shifted elsewhere. The petitioner was told that the land would be used by the Bharat Sanchar Nigam Limited for setting up their office and that this was being done in public interest. The petitioner was informed that arrangements would be arrived at to his satisfaction. 5, that the petitioner met with the respondent number 4 on many occasions and requested appropriate actions. He was advised, respondent number 4 is the Deputy Commissioner of Dimapur. He was advised to wait and assure redressal of his grievances. However, no action was forthcoming as assured. Instead, the BSNL began development works on the plot. As such, the petitioner submitted a written complaint to the district administration. By order dated 29/11/2000, the BSNL was restrained from construction work. That is Annexure A at page 12. It was a restraining order. 6, that after the above order, the petitioner was made to wait for a further period of time. As such, the petitioner addressed a representation dated 26/19 to the BSNL. In response, the petitioner received letter dated 24/6/19. By this letter, the petitioner was informed that an amount of rupees 58,894 had been paid to the Deputy Commissioner and that the land in question had been allotted to the BSNL. The said letter enclosed a land allotment order dated 10/8/81. The letter dated 10/8/81 contradicts the claim of the BSNL and states that the sum of money above referred is the cost of the buildings on the land. Also, the petitioner did not receive a single paise from the district administration. So whatever transaction they were, it was between the BSNL and the district administration. I have no idea, my lord. If you can go to the annexures now, my lord. The annexure B at page 13. This is my representation, and the response is at page 14. Annexure C.
So representation was submitted when?
My representation was submitted 26/2019. 26/2019.
Just a minute.
And annexure C, page
Land has
14.
never been compensated. No, have been seen. You have any document to show that this land belongs to you?
Your Lordship is aware that in most of the areas in the state of Nagaland, lands are privately owned. Only the Dimapur Moza has patas. Otherwise, this is village land. Ma'am.
Okay.
This is village land.
Any certificate from the village authority? Or
That will come to that, ma'am.
okay.
We'll come to that.
So this letter, page 13 is
Is a representation.
request for compensation
Yes, ma'am.
to the general manager.
Yes, ma'am. Regional manager.
Okay, and reply is at 14.
At page 14.
Just a minute. Okay,
14. May I read this letter, my lord?
just a minute. Huh?
This letter is pertinent.
Hmm.
This is dated 24/6/2019. Request for compensation of land of microwave office regarding. On the subject above, this is to intimate you that BSNL has set up a telecom center at Zinapato at the aforesaid place Children's Park measuring 200 into 200 square feet as per the land allotment order by government number such and such dated 10 August 1981 by Deputy Commissioner Zinapato. Accordingly, BSNL has built the microwave station and subsequently telephone exchange in 1982. The land has been occupied by DOT BSNL after paying the requisite amount of rupees 58,894 to Deputy Commissioner right above allotment order. So, Your Lordship, may kindly note this. This amount was paid by the BSNL to the Deputy Commissioner. At this stage,
This is land revenue or what?
that also will be shown in the subsequent documents now.
Yeah.
At this stage, your representation seeking compensation of land at Zinapato does not arise. A copy of allotment order issued by the Deputy Commissioner is enclosed for your information, and if any further inquiry, you may approach this office. So the allotment order is at annexure D, page 15. This is dated 10th August 1981.
Okay,
May I read, my lord?
is okay. Allotted to the BSNL.
Yes, a plot of land measuring 200 into 200 at Children's Park and adjacent area in Zinapato town as per site plan is hereby handed over to the Divisional Engineer Telegraph's microwave project Jorhat on the following conditions. Department will pay rupees 58,894 only to the Deputy Commissioner Zinapato, being the cost of existing buildings and park. So only the cost of the buildings and park, not for the land. Standing on the site as early as possible, White Office letter dated such and such. This also refers to the letter dated such and such. Then, Your Lordship, annexure E is my representation to the government and to the Deputy Commissioner.
That's it.
Page 16.
Okay. This is okay.
Yes.
Yes.
His involvement of the government was also there.
Hmm.
Then at page 18,
This is,
My representation, my lord,
okay. To Deputy Commissioner.
to the commissioner, the government also, the deputy commissioner also, and then as well as the general manager, telecom, BSNL.
Hmm.
Then
Hmm.
my representation was processed. Your lordship can see that in page 18,
Hmm.
page 18,
Hmm.
then page 19.
Yeah,
process-
just
the
by the
process-
secretary to the illegal allotment.
The process, my lord.
Hmm.
And page 19, this is the same order, your lordship, which I, not exactly the same, but this is the document in question by which the BSNL came into possession of the property. The type copy is at 19B,
19 is,
the agreement.
no, 19 is the document, what is this document about?
19, this is a letter written to the BSNL asking them to show their documents regarding how they came to be in possession.
Okay.
Then 19A,
Hmm.
then 19B is the type copy. 19B in the next page.
Okay.
May I read?
Yes, yes. Yes.
Agreement for allotment of land to divisional engineer, the telecom microwave project is in Nebato, Nagaland. Whereas the divisional engineer telecom microwave project approached the district administration in Nebato for allotment of land as Nebato town for construction of microwave tower and office. Some parts are illegible, my lord. For the space is located on land on which Nebato Children Park, which is under central and supervision of the Nebato Town Committee. And whereas the area measuring 200 into 200 has been earmarked for the purpose, and whereas the divisional engineer microwave project, some portions are illegible, my lord, located on a children park on payment of approved rate of rent to the government. And whereas 200 and 200 around the children's park is hereby allotted on lease. So it is not a land which has been acquired by the BSNL in any means. It is a lease which was granted to the BSNL.
Allotment normally is on lease only for say around 30 years. All allotment by the government.
Your lordship, in our case, in the state of Illinois, allotments are more or less permanent, my lord,
Okay.
subject to payment of yearly land revenue.
Normally it used to be lease, subject of course, it will be renewed only after 30 years.
That would be under the Assam Land Revenue Act.
Okay.
But we don't follow that. Here, allotments are usually more or less permanent.
permanent.
Payment of land revenue,
Okay.
yearly land revenue.
Okay.
So this is on lease. This is not an actual allotment, your lordship. This is a lease agreement.
Okay.
This is a lease agreement. The next document, your lordship, at page 20.
Just a minute. This document, what do we call this document?
This is an agreement, my lord.
Agreement by between
The agreement between the divisional engineer telegram
and
and
the district administration.
the district administration, my lord.
Okay.
District administration.
Okay.
And next letter, my lord, this is letter written by the BSNL to the SEO Civil Zinamoto. This is in compliance to your letter number mentioned under reference in connection with the above mentioned subject. Since the site allotment for the microwave station in Zinamoto town dates back to the year 1981, we are hereby submitting the only available documents in our office as follows. Land allotment order from Deputy Commissioner dated 10/8/1981. 2, acknowledgement of the receipt of check number such and such for rupees 58,894. 3, agreement for allotment of land on lease. So they also acknowledge that it is a lease on to Divisional Engineer Telegraphic Microwave Project at DIFO in the month of December 1982. Then next letter.
Now, if the land belongs to you, on what basis this district administration or DC has allotted the land?
That is precisely proper. That is precisely the point, my lord. In the year 1979-80, for some emergent purposes, law and order problems, they took over my land. I built barracks for accommodation of the police. In the introductory parts of my writ petition, your lordship, which I mentioned, this land was subsequently given to the BSNL by the district administration. Without my consent, without my knowledge.
So there are some document between you and the administration.
Verbal agreements, my lord. This is how
Verbal.
things used to work before, my lord. This is how things used to
Your representation is to the BSNL only?
My representation to the state also, my lord. Subsequently to the state also.
State also. What is the reply of the state?
I'll come to that.
Okay.
I'll come to that. Then annexure I at page 21. This is a submission of maps cum survey report of She Yashas Zmomi, land occupied by BSNL Telecom Exchange Nevoto. Now, this is by the District Land Records and Survey Officer. So this is the office which is entrusted with the land records in town. So this is the letter dated 27 September 2019.
Yes.
With reference to the subject cited above and with reference to the office letter dated 23/9/2019, I have the honor to submit the map of land belonging to Sheikh Yashas Zmo, which is presently under occupation of BSL.
Who is this?
The petitioner.
Kesha Jimo is,
Yes,
okay.
the petitioner in this is the case.
Hmm.
So this is the acknowledgement by law that the land belongs to me.
So the land belonging to so and so,
It's
which is presently under
occupation
occupation
of
of the
BSL
BSNL.
Telecom Exchange in Zinabadu town. The survey was carried out by the technical staff of this office on 24 September 2019. The area was calculated at 2,409 square feet or 25,932 square feet. The survey area was found to be free from all encumbrances. This is for your information and necessary action, please. Then 22 is the map in question, Your Lordship. And the map also very clearly states that this is the land belonging to me.
Showing the details of land belonging to.
Map showing the details of land belonging to Kesha's.
Right, this. This was issued by
The surveyor, my lord.
surveyor only.
My lord, and this is in the office of the District Land Records and Survey Office. This is a part of the letter dated 27 September 2019. Same, Your Lordship, 23. Google Earth image is page 23. And page 24, my lord. This is now addressed to the government, to the commissioner by the deputy commissioner. The commissioner of Nagaland by the deputy commissioner. This is letter dated 26 November 2019. To the commissioner, sir, in inviting a reference to the subject cited above, I have the honor to forward herewith the meeting minutes of DLSB held on 21 District Land Survey Board, 21/11/2019, along with the original documents regarding outright purchase of BSNL occupied land at Old Town Colony, Nevoto. This is for your kind information and necessary action, please. So this is the District Land Survey Board, Your Lordship, and this is the minutes of the meeting, which is at page 25, type copy at page 27.
Okay.
And at page 28 is the reference to my land at serial number 3, page 28. BSNL land at Old Town Colony is Nevoto. As per the survey carried out by the LRSO, the total area of the above mentioned land is 25,000 and odd square feet. It was handed over to the Divisional Engineer Telecoms by order dated 10 August 81 after payment of rupees 58,894 as the cost of the existing buildings, not as by way of acquisition and park infrastructure present there and paid accordingly, which was not for the cost of land. Till now, the land has not been purchased by government BSNL and that the BSNL has been occupying the land since 1981-82. The land was leased out on payment of rent. So it was leased on payment of rent at the rate of rupees 60 per acre in the year 1982, which was not paid nor revised as per available records. So even the lease premium has not been paid. They're just in occupation. As per the land rate of the Deputy Commissioner in Nevoto, the land falls on the commercial category A with the rate of rupees 120 per square feet. Therefore, the total cost of the land comes to 31 lakhs and odd. The AGM planning, GMTD, Nagaland SSA was represented by junior engineer who agreed to apprise a higher authority on the matter for a concrete decision to be arrived at. The committee members recommend for purchase of the said land. So this recommendation of the District Land Survey Board was forwarded to the commissioner, the highest authority as far as the administration is concerned in the state. This is where it stands now. So my case is this. My land was taken without following the procedure prescribed by law. If the BSNL wants my land, it must follow the procedure prescribed. That is my case now. Now the state said, as far as the state is concerned, Your Lordship, the state's affidavit, respondents number 1, 2, 3, and 4.
Affidavit 1, 2, 3, and 4.
Yes, 1, 2, 3, and 4. And the Lordships may come to paragraph 3. Paragraph 3.
Okay.
So all these paragraphs are matters of record, not denied. Then paragraph 4. paragraph 4, which is in relation to paragraph 3 of my writ petition.
Hmm.
And this is where I stated about the land being given to the district administration at their request, and this is what they say.
Hmm.
That with regard to the statements made in paragraph 3 of the writ petition, is admitted as borne by the records. However, the answering deponent humbly begs to state that a portion of the land was converted to a children's park with some building infrastructure under the supervision of the town of this neighborhood town council. There is no dispute with that. But the fact that it was my land which was taken by the district administration, that is not denied. That is not denied. Then paragraph 4, your lordship. Paragraph 4 is where I say that the land was given to the BSNL, and the reply to that in paragraph 5. With regard to the statement made in paragraph 5, the petition is admitted as it is also borne by the records. However, the answering deponent pertinent to mention herein that the said land was given on lease, so it was not given, the land was never acquired at the rate of ₹60 per acre per year to the division engineer, wherein an agreement for allotment of land was executed between the parties on dated 1982. Then what I am saying, my lord, what I am saying as far as my rights are concerned, my lord, I say that more particularly in paragraph beginning from paragraph 14 onwards, 14, 15 of my writ petition.
Paragraph 14 of
my writ petition, 14, 15, 16, 17. 14, 15, 16, 17.
Yes.
14 says that the state and the BSNL are liable to pay rents to the petitioner from 1979.
Okay.
He is also entitled to receive just compensation in terms of the act, that's the Acquisition Act. That 15, that in the state there has been practice for private property to be taken without recourse to due process. On the part of the citizenry, such actions have been condoned on assurances held out by the state and its instrumentality. As in the case of the petitioner, landowners have been assured of subsequent arrangements to their satisfaction. For the petitioner, the expectation on the assurance received has thus far been belied. The state and the BSNL cannot be permitted to trample upon the rights of citizens. In the scheme of the Constitution of India, there is no room for illegal deprivation of citizens' property by the state and its instrumentalities. Now, this you will see in paragraph 3 of the reply of the counter filed by the state, madam. The state does not deny this. Paragraph 3, your lordship got that? There are statements made in paragraphs 1, 2, so and so, so and so, 14, 15, 16, 17, 19. The answering deponents offers no comments as borne by the records. It's just a vague denial, just saying no comments. So basically, it's an admission matter. There are specific agreements which otherwise ought to have been denied. Now, paragraph 11 is about the District Land Settlement Board, the recommendation. And the reply to this is at paragraph 8 of the affidavit of opposition of 1, 2, and 4. Paragraph 8. Look at paragraph 8. That with regard to the statements in paragraph 11 of the writ petition is admitted as borne by the records, the answering deponent is pertinent to state that on 21/11/19, the DLRB had held meeting at the office of the Deputy Commissioner, wherein in that meeting the said land was recommended by the committee member and proposed for outright purchase through the District Land Settlement Board. However, it is yet to receive the approval of the Land Acquisition Authority. This is 11. Then paragraph 12, my lord. This is where I talk about acts which regulate the acquisition process now. At paragraph, the reply to this is at paragraph 9. That with regard to the statements in paragraph 3 and 12 of the writ petition is admitted as borne by the record. So there is another here, as far as paragraph 3 is concerned, your lordship, another admission. However, the answering deponent humbly begs to state that as the petitioner himself has admitted that the said land was occupied on request due to circumstances on the request of the district administration and for a public service with the prior consent of the petitioner, who himself has constructed a brigade barracks for the police personnel in the area during the war, period of law and order emergency. So what I have stated, the state admits. So this is as far as the state is concerned. Now, BSNL, what does the BSNL say? The affidavit of the respondent number 5. Paragraph 3, my lord, at page 3.
Yes.
Paragraph 3 at page 3.
Mm.
That the deponent at the outset begs to state that the government of Nagaland, through Deputy Commissioner Remoto, in exercise of the vested rights in the land, has transferred the erstwhile government park in favor of BSNL for value received. So this is a wrong statement, my lord. The documents, their own documents clearly show that land was never transferred. It was taken on rent. In other words, BSL acquired and possessed immovable property measuring 40,000 square feet in the year 1982 on payment of a sum of rupees 58,000 and odd, only subject to the condition that BSL will pay rent at the rate of rupees 60 per acre per year to the state government. At the same time, they say, yes, they have taken the land on rent. So the fact which is now established is, my lord, the land has not been acquired. The due process of law has not been followed. What is the defense that they take? Your lordship will find that in page 4, paragraph 6. May I read paragraph 6 now?
Yes.
That as regards the petitioner's averments made in paragraph 2, 3, and 4 of the writ petition, the deponent states that the petitioner has nowhere adverted that the barracks on the land were constructed and allowed the government to possess the same for police accommodation without value received, nor it is the case with the petitioner that the government possessed the property in question agreeing to pay rent. So it is crystal clear that the government acquired and possessed the property in question for value paid. Thus, the right of interest in the property had been vested in the government since 1979 until the government allotted it to BSNL. As such, it is voluntary cessation of ownership right of land in question. In view thereof, petitioner has no any right in the land possessed by the police or the BSNL. This is clearly a wrong statement. Then, at paragraph 8, paragraph 8. Paragraph 8 is Lordship got paragraph 8.
Mm.
That is regards the petitioner's statement made at paragraph 6 of the writ petition. The deponent begs to state that a true and correct fact was informed to the petitioner about the allotment of the land in question in favor of BSNL by the government on payment of amount of rupees 58,000 and odd, and the government has rightly allotted the land to BSNL as all right of land was vested in the government of land since 1979 when the petitioner handed over the barracks for police accommodation. Wrong statement, my lord. Be it further stated that payment of 58,000 and odd in 1982 was a condition for allotment of the said land. Thus, the BSN paid the sum of rupees 58,000 to the Deputy Commissioner of the Remoto, being cost of the structures, building, etc. And in consideration of a said amount, the yearly rent, rupees 60 per acre, are reserved to be paid to the Deputy Commissioner of the Remoto, allotted the land in question to BSN to cater service to the public. As such, possession by the property in question by virtue of the land allotment by the Deputy Commissioner of the Remoto. However, if the petitioner was owner and he has not been in receipt of the said sum of rupees 58,000 and odd, the petitioner may approach the government, in particular the Deputy Commissioner's Remoto, for payment of the said amount to him, and the petitioner has no right to demand to proceed or proceed against BSNL to realize any amount inasmuch as, by virtue of uninterrupted possession of the land for a long 38 years without paying rent, BSNL has already got the ownership of right of land by right of adverse possession. So these are the two grounds taken. The first ground is land was allotted and land was acquired on basis of acquisition. Land was not allotted, my lord. It was taken on lease. Acquisition was not paid. Only cost of the barracks and the buildings was taken. The first defense is demolished, lordship. The second defense of reverse possession. Can the state and its instrumentalities adopt the plea of reverse possession? That is settled law now. They cannot take that plea. If the state wishes to take property, it can only resort to the procedure prescribed by law. That is the acquisition process under the Acquisition Act. That is my case. This is basically my case, lordship. The facts are covered. The points of law are placed before your lordship. I will place the authorities now, my lord.
Okay.
Where is this? Please hand over that to. No. Yes. Well, sure, I've just called out the principles to make it easier, my lord. The paragraph numbers are mentioned, but the principles.
Mhm.
The first one is 2020 4 SSC 572 deal with
Yes.
Basnet,
Yes,
paragraphs 13, 14, and 15.
okay.
It is the burden of the state to prove that land has been acquired in accordance with the procedures established by law.
Hmm.
Only if it is proved that the land has been acquired in accordance with the procedures established by law, then I lose my case. In our case, my lord, the records are very clear. The pleadings of the parties themselves are very clear that a procedure established by law has not been followed. No acquisition process. In the second one, my lord, 2007, 17, 11 SSC, paragraphs 88, 89. If the manner of doing a particular act is prescribed under any statute, the act must be done in that manner or not at all. Acquisition proceedings in derogation of the Land Acquisition Act are perverse and illegal and void ab initio. Such exercise of power by the state government for the acquisition of land cannot be allowed under any circumstance. So even in this case, my lord, the District Land Settlement Board, it decides in my favor. No doubt about that. But it is not the procedure prescribed under the Act. Acquisition proceedings must be decided by the district collector in terms of the Acquisition Act. Then the third one, my lord. This is 2022 SSC 569. This is the celebrated case of Vidya Devi, Your Lordship, where for the first time, the Honorable Supreme Court has laid down the principle that the state and its instrumentalities cannot take the plea of adverse possession insofar as it relates to the private property of citizens. This is the first case. In a democratic polity governed by the rule of law, the state cannot deprive citizens of their property without sanction of law. The state, being a welfare state, cannot be permitted to take the plea of adverse possession. The state cannot be permitted to perfect its title over the land by invoking the doctrine of adverse possession to grab the property of its own citizens. In the first place, my lord, there is no question of adverse possession here because the BSNL itself acknowledges that the land was taken on lease on payment of rent. Rent was not being paid. That's a different issue, my lord. So there is no question of adverse possession. Even if the plea of adverse possession can be accepted, my lord, the law laid down is now very clear. The state and its instrumentalities cannot take the plea of adverse possession and claim perfection of the title. So therefore, my lord, my case is this. The BSNL is an illegal occupation of my property. Therefore, if they want my property, the land has to be acquired in terms of the Land Acquisition Act. That is my case, my lord.
Okay, so today we have been requested by the bar, is only after 1.
Well,
So I think we have hardly time. So what we can do is some other matter also will finish and part in part,
my lord,
your part I have heard.
my lord.
So their part, next date. Tomorrow if it's possible.
Tomorrow?
Tomorrow I have some personal difficulty.
You have some personal difficulty.
I would take much time, 5 minutes. It's very 3 minutes. It's a.
No, We have to sit only after 1, after 1 only. Now, specifically today, there is a request from the bar association. Tomorrow, if it is 15 minutes or 5 minutes, 5, we don't have a 5 minutes also. We have hardly 4 minutes. Monday, probably I will not be here.
If they can finish in 5-10 minutes, I think we can wait for 5-10 minutes.
No, especially the bar association came.
Yes,
And
I
I
know.
know there is
Yes,
a
I'm
request
aware of that.
up to only 1.
My lord.
So your meeting will start at 1.
My lord.
We have committed. Tomorrow, come tomorrow. Hmm.
Malo for me is typical Malo. I'm going normal.
So that your
Additional affidavit, everything we have admitted, Malo.
Admitted.
Yes.
Okay, anything to submit then?
In the additional affidavit.
Additional affidavit is also there.
Yes, Malo. Additional affidavit filed by.
Affidavit.
Yes.
Okay, additional affidavit is also filed by you. Yes, 1 to 3. Okay. Beyond that, anything to submit?
Yes. Completely forwarded the additional case to the government and the government is said to.
Okay, it is there in the additional affidavit?
Yes, yes.
Okay, and anything else?
That's all. We are
Okay,
relying on the-
your part will hear it tomorrow. Okay, then in that case, it's anything else other than that? Any authority? No. Okay, then it's, I think,
Finish, madam.
hard, yeah? Cool. Okay, cool. Nice. Okay. Hold on. Okay, ask Mr. Ejimoni, Learning Council for the petitioner. I've also heard Mr. Kibapong, Learned Senior Government Advocate for the state respondent number 1, 2, 3, and 4, and Mr. for appearing on behalf of the BSNL respondent number 4. 5, sorry. Hearing concluded, judgment reserved. Okay. Much obliged.
For item number 11 earlier.
Yes, yes.
The council was not there. Now she said if we can trade at 2 o'clock after the meeting.
After meeting.
Yes, after the press conference. At 2 o'clock, we can try it.
So, item
Item number 11, Lordship.
11 is, this is about what?
Work charge regularization, my lord. It has become infractious, my lord.
Okay.
Earlier, I placed one order, but the
Okay.
council was not there.
Now, if it become infrastructure, you place the order. No,
It
no.
was passed over for tomorrow, but then since she's here, we can do it.
So it has become infrastructure. You have complied with the case, complied with, and then it has become infrastructure because you have got the relief. Okay. Then item 11, huh? Hard, Mr.
My lord,
Hmm.
my lord, if I may just take 2 minutes, my lord.
Okay.
My lord, I've made a.
No, no, if it is complied, then it has become infrastructure. We'll
Yes,
close
my
it.
lord. To the extent of regularization, but
Okay.
with regard to areas, my lord, since he has been regularized, effective date of regularization is 30/03/2020, my lord, as per the regularization order. But that can also be reflected, my lord, while.
Which one? Effective date of regularization,
Yes,
30/3/2020.
30/03/2020.
Yes.
Just an observation, my lord, to that effect, if there's any areas that might be eligible to us, my lord. Because I've made a specific prayer for areas as well.
Okay, Mr.
Yes, question.
Okay,
To show long, my lord.
Learning Council for the petitioner. The hard Mr. Spencer, Learning Council for the petitioner, and Miss Jung for the state respondent staff, huh? Miss Chang, Samistat, the grievance of the. Was there any direction in this case?
My lord, this is coming up for the second time. Lordship.
Second time
Yes.
only. Okay. So your prayer was for even for the
Areas, Lordship.
areas
Any other
also.
benefits?
Area not covered here.
It is not specifically mentioned in the order. my lord.
Okay, then.
That is why.
Okay, the council for the party submits that the respondent has regularized. This is a regularization order.
Yes.
Regularize the service of the petitioner with effect from
33.
30/3/2020.
2020.
With level of pay, no need to measure. And thus the prayer of the petitioner has substantially been complied with. Redressed. No, so therefore, this matter has become infractuous. In view of the above, and in view of the above, and as the petitioner has become, as this petition has become infractuous, this petition is closed. Okay.
With regard to the areas, if assemblies may be.
Area you make, I think areas were different.
Because I've made a specific prayer in my petition as well.
Hmm.
my lord. So if at all.
Okay, then,
With regard to the areas, I have no instructions for you.
okay. Okay, the learning council for the petitioner submits that although the respondent has appointed the petitioner, however, there is no clear order as regard to the areas of
Yes, sir.
areas as claimed by the petitioner. The petitioner is at liberty to approach the appropriate authority for the for the areas, if so advised.
Yes.
Okay. With the above, this writ petition stands closed. Okay. Keep it in item 12. Item 11.
The order might be marked as
Okay, the order, okay, order placed by placing order, then the said order is taken on record and marked as document X. Okay.
Your Lordship, with regard to item number 24 and 25, this is with regard to minimum scale pay, Your Lordship. I was on my feet in court.
Okay, so this is covered case.
Yes, Your Lordship, I have received the instruction in item number 25.
Hmm.
The department has given a letter. They say that this case is covered, so.
Okay, so we can dispose of
Yes,
in the to give benefit as per this notification. Okay,
item number 24, this is also with.
this is also a scale, same
But Your Lordship, my humble submission is that with regard to the time frame.
time, 4 weeks,
Yes.
4 months.
Yes, Lord. If it's
Is it
4 months,
okay?
I-
4 months. Okay, 4 months. Okay,
In accordance with the.
in accordance with this
Yes,
notification.
yes.
Okay. This is item 24 and 25, huh? Keep it in 24 and 25. Both are same only.
Different department.
Okay, different department. But this notification is same.
Yeah, notification is same.
This is the same notification.
Yes.
Okay.
This is not a letter, this is not a notification.
This is not a notification.
This is the
Notification is there.
instruction
Okay.
Stating that the petitioner's case is covered.
Okay, this is for 25.
Yes. Your Lordship.
Item 25. Yes. Okay. 24 covered by the notification.
Yes, Your Lordship.
Okay. Okay.